Hello and welcome to the Thought Leaders for Fire virtual conference on the crossover of fraud and insolvency. I'm Mary Young of Kingsley Napley and I'm co-chairing this event with my colleague Will Christopher, who you'll meet a little later, and who my money is on as the snappiest dresser at this event. We've got an excellent panel of speakers this lunchtime with experience of insolvency and asset tracing all over the world. We'll be covering collecting evidence at the start of a case, changes in the insolvency laws in Guernsey, the dreaded Avonwick and Schlossberg, through to provisional liquidations and enforcement. We also have a truly international audience, with attendees from Hong Kong to Switzerland to Cayman. So whilst it's lunchtime in London, it's cocktail hour in Hong Kong and time for breakfast in the BVI. And while we're all trying to avoid mentioning COVID, Brexit, or any of the other overworked buzzwords today, I do think there's something really fantastic about being able to offer international speakers to an international audience from our own homes. So right at the start, I'd like to thank Paul, Danushka and Chris of Thought Leaders for making this happen. But that does bring me to you, the audience. As audience members, your cameras are off and you're muted, but we do still want you to participate. There's a Q&A facility at the bottom of your screen, which you can use to submit questions as the panels are speaking. If we can pick them up as we go along, we will do. Otherwise, we'll try to get to as many as possible at the end of the sessions. There is a designated question and answer session at the end when you'll either be able to type your questions, or if you want, we can unmute you so you can ask your question directly to the panel. So let's get on with it. I'm going to start with 4 experts in the field who I'm really pleased to be able to introduce to you. Paul Allen is a licensed insolvency practitioner. He leads the contentious insolvency team at FRP. He often works on cases involving complex fraud or attempts to disguise, shelter or dissipate assets. Paul's recent cases have involved the sort of enforcement and protective measures you'd expect in fraud proceedings. He's used to obtaining freezing injunctions, challenging offshore trust structures, and often works closely with forensic accountants and IT teams. Tamika Davis is a partner at Conyers in the BVI. She was called to the bar in the UK in 2003, has worked in Jamaica and Anguilla, and has over 11 years experience in offshore commercial litigation. Her expertise includes insolvency, conspiracy and asset tracing, as well as obtaining and resisting interim relief and disclosure applications. She's also been involved in the BTA Bank and Abli Azov litigation going on in the BVI. I should mention at this point, Tamika's just starting her day. I think it's quite early there still, and she has a court hearing starting before we're scheduled to end. So she'll be disappearing from your screens before the question and answer session. What that means is if you do have any questions you'd like Tamika to answer, please use the Q&A function while we're dealing with this first session, and we'll do our best to pick them up, though no promises. Then on to Colin. Colin Diss is another licensed insolvency practitioner. He's a director in the insolvency and asset recovery team at Grant Thornton, specialising in developing and putting into practice strategies to recover distressed, misappropriated and fraudulently obtained assets, often using liquidations, bankruptcies and court-appointed receiverships. He has experience in numerous jurisdictions, including the main offshore financial centres and the US. And finally, for this session, Nick Axup is a senior associate at Stevenson Harwood. He specialises in restructuring and insolvency, fraud and asset recovery, often with a cross-border element. His insolvency work is typically contentious and often involves fraud. He acts for insolvency practitioners, creditors, debtors and other stakeholders in both corporate and personal insolvency contexts. Nick also has experience of fraud cases and is currently acting on a case involving a confiscation order obtained by the Serious Fraud Office. So in our session, we're going to be discussing that really critical first stage of a case, which is evidence gathering. And I'm going to start by going to Paul. Paul, we've got quite a wide range of audience members with different experience. So for the sake of those who aren't insolvency specialists, let's start right from the beginning. Can you summarise what powers you have when acting as a trustee in bankruptcy or a liquidator to collect in evidence and what they mean?
Okay, hi Mary, and hello to everyone watching at home. I think that the two main sections are Section 236 and Section 366 of the Insolvency Act. 236 deals with corporate insolvency matters, and the court can require the production of books, records and papers from anyone that's capable of giving information about a company. Section 366 is similar, except that it relates to personal insolvency, so it relates to bankruptcy matters. And again, the court can require the production of books and papers and records relating to the bankrupt. These are particularly useful powers to rely upon in fraud cases, because generally in fraudulent cases, you don't get the full picture, you don't get the full delivery up of records. Sometimes you've got absolutely nothing to go on. We've had that in numerous cases where there's no books and records from the start. So you've got to try and piece everything together. The same with bankruptcy cases where you have an uncooperative bankrupt who is trying to deceive or put assets beyond the reach of creditors. So these are important powers to rely upon. I mean, obviously it would be a very time-consuming and expensive exercise if every time you needed to obtain information that you'd need to make an application to court. So in practice, what we would do at the start of a job is start of an investigation case. We would write to all of those parties who we think have information that will assist with our investigations that relate to the company. And typically, more often than not, we get delivery up of those records by making reference to Section 236 or Section 366. So those sort of inquiries can include banks. So we'd be looking to get bank statements, copy checks, copy transaction advices, mandates, anything else, correspondence with the bank, anything else that you think might be useful. The same of credit card providers, solicitors, so files relating to different matters worked on but for a company or an individual, accountants' files, tax files, auditors' files, including working papers, financial advisors, inquiries of the land registry, DVLA, and so on. So as I said, so what we would do initially is make reference to those sections and request the production of information from those third parties. If they're unwilling or refuse to deliver up those records, then we have the option to make an application to court for the production of those records in accordance with 236 and 366.
That's really helpful, and I think that gives us a good example of quite how wide those powers are. I'm quite interested in just how wide and just how far they go. Can you give us a bit, because part of the idea of this session today is about talking about personal experiences. I'd really like to know what sort of things you've been able to get using these powers. What's the strangest thing, and how have you managed to use them to really open up a case?
Yeah, so I don't know necessarily whether this is the strangest thing, but I can give you an example of a case where it shows using the 366 power in a bankruptcy how we were able to follow the trail and unlock the case. So this was a bankruptcy of a former trader who had earned in excess of £1 million a year for the 10 years leading up to his bankruptcy. And as at the date of the bankruptcy, he declared no assets and significant liabilities. So we were obviously concerned about that. So as part of our initial investigations, we got his bank statements, and on conducting a review of those statements, we had identified a payment to a firm of solicitors in the region of £1 million. So we wrote to that firm of solicitors, again, making reference to 366, and they responded to say that the payment related to a property purchase, but it wasn't in the bankrupt's name, it was in a female's name, and it was at that stage somebody that we weren't aware of. So we made inquiries to the land registry and found out that the property had been sold shortly before the bankruptcy. So we asked the bankrupt to come in for interview, and at the interview he said that the lady in question was his ex-girlfriend who he had a son with during his marriage, and they had separated a year earlier. It was acrimonious, and no contact with her, didn't know how to get in contact with her. As far as he was concerned, the house had been purchased for her and his son, and she'd gone with the money, and there was no way of helping us get it back. So from some discreet inquiries on the internet, we managed to find some contact details for this lady. So we emailed her, and she basically responded to say, get lost, and confirm the same story. I haven't seen the bankrupt in over a year. We've separated on bad terms. So given the bankrupt's conduct in other matters that we were looking into, we were a bit dubious about this. And so we conducted a bit of social media investigation, and we found her open Facebook account, which showed a picture of this lady and the bankrupt in Barbados 3 months prior to the date in question. So post bankruptcy at this point, and certainly months after she and he claimed that they had separated. So we put this to both of them and said, well, how do you explain this? And she responded to say, well, the picture was actually taken 18 months earlier, but posted 3 months ago in order to make my current boyfriend jealous. And the bankrupt responded and said, I've managed to get hold of her, and she told me that this is why it's been done. So we didn't believe that at that point, but we didn't really know what to do about it. And then somebody had a bright idea about making a request, 366 request to the border agency. So we did that, and then got production of all of the bankrupt's records showing his entry and exit of the UK borders, which showed that the trip to Barbados was in fact 3 months earlier, as they said. And we've used that information to suspend his discharge from bankruptcy and obtain a judgment in excess of £1 million against the so-called ex-girlfriend. So it had a huge impact on the case.
Really interesting, and just shows the sort of information that can be obtained using these powers. Thanks very much for that, Paul. We have already had a question on here, and whilst it is described as a question to Paul, I'm actually going to bring Colin in on this one, because Colin, I wanted to talk to you about exporting these sorts of powers, and Alina has asked how easy it is to exercise bankruptcy trustees' powers outside the UK's jurisdiction, e.g. in the US, EU and other countries. So Colin, can I come to you, and I think if you could talk to us about your experience of taking those powers outside the jurisdiction of the UK.
Sure, very happy to. Good afternoon, everyone. Thanks for joining the webinar today. It's great to see so many people online. And thank you for the very kind introduction, Mary. Much appreciated. Yeah, so I was going to talk to that topic precisely by way of a case study. But just by way of background, Paul has alluded to the investigations that have been conducted in the UK. I know I do, and I'm sure Paul does as well. We find cases particularly involving fraud, no boundaries, geographical boundaries or time zones, and we can find ourselves globe-trotting trying to obtain disclosure and assets in relation to bankrupts, debtors and defendants. So as officers in the UK, we quite often find ourselves needing the assistance of foreign courts to realise assets for the benefit of creditors. So I'm going to talk to you about a very recent case that's still ongoing, actually, so I can't name it in person, but has involved myself seeking recognition of a UK bankruptcy in the United States under Chapter 15. So myself and Nick Wood were appointed as trustees in bankruptcy here in England. As Paul's already alluded to, the bankrupt, displayed zero cooperation, failed to fill in his questionnaire to the OR appropriately.
That does seem to be a theme.
Yeah, the normal, it's no assets, loads of liabilities, haven't done anything wrong, poor old me. And you just completely went radio silence, didn't even contemplate challenging or setting aside the stat demand or the petition that preceded the bankruptcy. So anyway, we were appointed, and we normally work on a phased approach. So as Paul's already said, we obtained bank statements, accounting records, tax records, etc., etc. What was interesting here was once we got hold of the bank statements, we could see that there were regular flights to the US, particularly Miami and Tennessee. We could see that he'd drawn down his pension lump sum and immediately transferred that to a SunTrust account in Florida. And we could see transactions going through on his credit card for everyday purchases, again, in Miami and Florida and Tennessee. So that put us on a train of inquiry into the US. So we conducted some in-house corporate intelligence, human intelligence, and asset tracing. And we found that the debtor had effectively a second life in the US, which nobody seemed to be aware of.
Wow.
We found a driving license in his name, which was associated to a property in Tennessee, which was in his name. We found an LLC company that was registered in Florida, and I'll come back to that, and several bank accounts in the US. So I was left with the predicament as to how I utilize that information and ultimately realize assets for the benefit of the estate. And I suppose I had two options in my mind. The first one was, I'm aware, I know that Tamika will come on to talk about this, is the ability to seek disclosure in the US under 1782. Or I could take the route through the US is enactment of the UNSUTRA model law, which enables cooperation across borders, and instigate a Chapter 15 recognition of my appointment here in the UK in the US. So I took the decision to go down the Chapter 15 route. The principal reason behind that was that by doing so, I would automatically get a freeze over the assets on recognition of my Chapter 15. So effectively preventing other creditors that may be in the US or other jurisdictions from seizing those and preventing me from realizing them for the benefit of the estate back in the UK. The second big reason was I felt that I would end up litigating in the US to recover the assets. And I wanted to have not only the US toolkit available to me, but also Chapter 15 enables me to export my powers as a UK office holder into the US.
Sorry, so just to clarify, so you would be able to take the Section 236, 366 over to the US under Chapter 15?
I wouldn't necessarily need to, and that's a topic I would definitely have to kick out to the lawyers and counsel on the call, because it's an absolute minefield, international recognition of powers. But I can safely say that I'll come to it again, is we would be required in this instance to potentially bring a Section 238 claim, which is a transaction under value under the English Insolvency Act, but we could bring that claim in the US through the US courts with the assistance of the US courts. 236 possibly, again, defer to lawyers, but Chapter 15 enables in its own right very wide-ranging disclosure. So I'm able to examine witnesses under Chapter 15. I can take evidence. I can obtain information from third parties that have information in relation to the assets, the affairs of the bankrupt, their rights, their obligations, their liabilities. And chapter 15 is also federal. So once I'm recognized in a particular state, that can be exported across the US territory, which is quite helpful because I had assets in multiple states in this particular bankruptcy. And in terms of the process, it's relatively straightforward, I found, and it's relatively inexpensive. I mean, the court filing fee is less than $2,000. You will need to obviously pay for legals within the jurisdiction to obviously file the application, and whether or not the application is contested or not will ultimately dictate how expensive and lengthy that process is. But once we were recognized, I can operate in the US effectively as if I was operating in my home jurisdiction. So as Paul did in the UK, I was able to then subpoena and obtain disclosure from the US banks. I was able to disclosure from the LLC company and its auditors, its lawyers, its solicitors. I was able to subpoena the girlfriend that was in the US, and we
always about the girlfriends as well, isn't it?
They're always the ones that let it slip. And we were able to unlock a portfolio of assets, 7 properties, 2 of which were held directly in his name, 5 of which were held through his LLC company. The properties held in the LLC companies were transferred from him personally just prior to bankruptcy for $10 a pop. Hence why I was quite keen to bring the transaction and the value claim that we have under the Insolvency Act in the US.
Yeah, it all sounds really interesting. Colin, I'm going to cut you off at that point just because I'm conscious of trying to keep to time.
Sure.
I would like to come back to you a bit later on just to talk about some practical tips.
Sure.
And guidance about that sort of thing. But what I'd like to do at this point, and apologies for cutting you off,
no problem at all.
I'd like to pass on to Tamika, because you mentioned Section 1782 and obtaining disclosure. Tamika, I would like to come to you to talk about 1782 applications, what they are. Let's not assume that anyone knows what these things are, and how they work, how you've used them.
Thank you. I should start off by saying that Section 1782 is a US process. So I'm not a US lawyer, but it is essentially a process in the US whereby you can apply for and obtain information against a person in contemplation of foreign proceedings. Now, the Section 1782 relief is quite broad, and the source of information that you can get in terms of the disclosure is a lot wider than the sort of disclosure you would get in the BVI. So it is a useful tool. The issues that typically arise in the BVI from a Section 1782 application are usually, how will the evidence be treated in the BVI? So evidence that's obtained pursuant to a 1782 order, how will a BVI court view that evidence? That's the first issue. The second issue, and this is subject to a lot of debate in the US, which is whether a Section 1782 application, whether it has extraterritorial effect. And that is certainly a very interesting topic. There doesn't seem to be any resolution. There appears to be 2 cases which says it does and 2 cases which says it does not. And that effect is relevant for this purpose. You could technically have a 1782 request. And what that is the litigant come into the BVI asking that a BVI court recognizes a Section 1782 order. And it hasn't yet been tested in the BVI. But the question arising from that is, will a BVI court recognize a Section 1782 order? And you may say yes, because of comity and issues surrounding comity. You may say no, because it may be suggested that it is an attempt to circumvent our own disclosure rules, which are obviously a lot more narrow. You're only able to get disclosure where it is directly relevant to the issues in dispute. So there's been a lot of debate about whether a BVI court will recognize a Section 1782 order or will act pursuant to a Section 1782 request because of the public policy issues. But in the BVI, I think insofar as it concerns the public policy issue, a relevant factor is this. In the BVI, we have the Evidence Proceedings in Foreign Jurisdiction Act. It is rarely used, but it allows a person who intends to commence foreign proceedings to examine someone in the BVI for the purposes of obtaining information or obtaining disclosure. So that is a very useful mechanism. The reason it is rarely used in the BVI is BVI company directors are not located here. They tend to be located in places like Russia and China. So the directors are not likely to be here if they are persons. But usually directors of BVI companies can be corporate entities as well. And directors of BVI entities can also be professional directors. And what I mean by that is they are offered by the actual registered agent. So they would be persons, nominees, essentially, without any connection to the BVI company at all. So we have a similar act. And I state that because it will be relevant to whether a Section 1782 request will be recognized. And in my view, it would be, because you have a similar act, so there's no question as to whether the public policy in the BVI is anti-1782. So that is sort of the intersection between a Section 1782, a foreign process, a US court disclosure process, and how that will interplay in a BVI litigation or against BVI individuals who are directors or who would have some connection to a dispute.
Really interesting, thanks. And I think that sort of insight is exactly what we're looking for here. So I'm really grateful for you explaining some of that. I'm going to come back to you in a little bit about other common law actions in the BVI. But first, I want to go across to Nick, because we've been talking about different powers, Nick. What about investigatory receivers under CPR Part 69? Can you tell us about them, when you might want to use that, and what you might be able to use it for?
Sure, thanks. And good afternoon to everyone. And thanks again, like everyone else said, for the introduction, Mary. It's very kind. The principle of a receiver and a Part 69 receiver is not a new one. It's a familiar beast, and many of us will have seen it, particularly in the context of freezing orders, following on from freezing order to secure and preserve assets. Or recently, since the Masri judgment in relation to enforcement of judgments, to take over assets of non-paying judgment debtors, realize them and pay them over to a judgment creditor. So we're talking about a very similar beast, really. The powers of receivers are as people will have seen in orders, they're tailored and specific to the case that they're appointed on. It seems to me that the area of receivership is developing and actually needs to keep up with modern day fraud. It was mentioned earlier about and been discussed the movement of cash and assets around the world, and how it's a very different world to when this was, to when the Act was introduced in 1981, the Supreme Court Act. And one area that I think that it's developing, and where I've recently had, I say success, but it was limited success because we didn't actually get into the receivership, but they actually settled at the door of the hearing, which I think we should probably mark down as a success. I guess settlements are successes.
Absolutely.
I think might.
Absolutely.
Yeah. So, is that we tailored the powers very specifically to be away from the management and preservation of assets, and very much into the investigation into, well, pre-judgment actually, but the defendant's affairs, dealings, property. So the similar types of concepts we're used to in the Insolvency Act, effectively what the defendant has been doing with its assets, where they may be, and then report back to the court. The beauty of a Part 69 receivership is that the receiver isn't relying on powers set out in acts and having to go and ask people for them. They are acting as the defendant themselves. So it has potential very great ramifications. So, for example, access to agents, access to physical premises where documents may be located. And I know search orders and seizure orders are something that we have the right to do under the Insolvency Act, and which are carried out very regularly. But outside of the insolvency world, I think there's the scope under receivership to expand somewhat the scope of a receiver. And this isn't purely speculative or conjecture as to how it may develop. There's recently been over the last 10 years, there have been 2 Canadian cases on the topic. I'm not aware of an English case, albeit if other people are, then I'd really like to hear about it. The Canadian case was founded on an employee who committed a pretty basic fraud of misdirecting supplier payments to a bank account of a company of himself. Tracing it was proving very difficult, and a receiver was appointed to conduct an investigation into where that money went, to then eventually appointed over that company and to manage that company's affairs and bring the money back into the control of the company. But the investigation element was quite a big development, and was confirmed by the Court of Appeal in Canada as well in a following case. The limits to it, I think, are obvious. I don't think that any court is going to sanction, especially pre-judgment, a roving investigation by a receiver into everything going on in the defendant's world. I think we're going to have to be quite specific, and in the case I was involved in, we limited it to very clearly individual companies of which we were aware that money had gone to in the relevant fraud, and then into very specific powers that were being given. So it wasn't effectively the power like a liquidator to replace directors and conduct the business of the company, or to take over all of the functions of the company and administration, for example. It was very narrow as to the powers they needed to investigate what was happening and then report back to the court. And I think it was mentioned earlier that these things are done in stages, and that was very much our approach. Let's take the stage of finding the information before we work out how we may act on it. And I would love to hear anybody else's examples in due course, but I think it's an area of investigation to gather the evidence we'll need pre and post judgment in fraud cases.
That's really interesting. I was actually just about to ask whether it's something that you could do in stages, because it sounds like the sort of thing where you could do it incrementally, but you've already dealt with that. So that's.
I think it would have to be incremental to get the court sanction for it, to be honest, especially discussing Tamika's point, taking it to other jurisdictions to conduct investigation.
Excellent, thank you. Now, Nick mentioned search and seizure orders, search orders. Paul, if I may, I'm going to come back to you. We've talked quite a lot about the statutory powers, but what about other options? What about things like search orders? Have you used them, and have you used them to good effect?
Yes, I have, Mary. Yeah. So I think they can be really valuable, but it's not something for every case, and I think that's quite obvious. And
I think we can all agree with that. Yeah.
I mean, one of the options, obviously, if you've got a situation where a director or a bankrupt is telling you that something doesn't exist, but you suspect it does, and you suspect it's at their home, then those sort of situations lend themselves to an application for a search order. It's something I've done on quite a few occasions. I've a couple of examples for you. One was in administration where, following the appointment, we suspected a fairly large fraud within the business. And when the team were on site on day one, imaging the computers and doing all the other steps that you do on day one, we were unable to locate the backup tapes. So this is all before kind of cloud backup. So we asked the MD if he knew where the tapes were, and he said he hadn't seen them. And later on that day, one of the finance team said, I saw the MD leave the office with a box of backup tapes, put them in the boot of his car and drive off at the end of the day. So we then applied for a search order and turned up at his massive house on just off Hyde Park and searched the house from top to bottom. Unfortunately, that was a mistake. We started at the top and worked our way to the bottom and found them in the basement, but some 7 hours later. But we did secure the backup tapes, and all the data on that was really helpful for our claim against the director. Also, so another example of doing the same thing in a bankruptcy case. So it was the bankruptcy that followed a substantial judgment against a debtor for his involvement in a fresh air invoicing fraud. And the judgment was littered with loads of helpful comments for us about how deceitful this individual was. So, much like Colin's example, we wrote to him and he said, I don't have any assets, massive liabilities, obviously. And as part of our standard inquiries, we said, can you deliver up your laptops and any financial papers? And he said, I don't have any. I don't have access to a computer and I don't have any financial papers. So we thought, given the background to the case, we could get a search order, which we did. And so we, again, it's ex parte, obviously attended at his home address, found some computers, took them back to the office to image them, found papers about unknown bank accounts. So two examples, different, but useful and really beneficial both times.
That's excellent, thank you. And again, it's that sort of the whole purpose of this is to talk about the sort of the crossover. So using the fraud, what you would ordinarily think of as a sort of fraud arsenal to unlock the bankruptcy, and is really interesting. I'm now going to scoot back to Tamika, because what I would like, I know in our planning discussions we were talking about Norwich Pharmacal applications and the way that they work in the BVI. Could you talk about some of the differences there, how they work, and perhaps just mention any restrictions there are on the information that you might obtain through either those or 1782 or any other applications that you might make for disclosure?
Sure, Mary. A Norwich Pharmacal order is typically used in the BVI or applied for and obtained, because there are two unique elements of litigating in the BVI that are special. The first is we don't have pre-action disclosure under our civil procedure system. And you cannot get relevant information about a BVI company from a public search. If you were to search our online system, the only information that's publicly available would be the Memonarts, the certificate of incorporation, and just a tracking of activities in relation to that BVI company. Nothing of significance and nothing particularly relevant. For that reason, Norwich Pharmacal orders are frequently used in the BVI. What is it? It's a disclosure order against a third party who's been unwittingly mixed up in the particular dispute. That's what they are. In the BVI, they're typically used against a registered agent. Now, who is a registered agent? Every BVI company is required to have a registered agent. And it's basically the body that administers the corporate affairs for the companies. So it does its filing, it offers its registered office, it even offers nominee directorship services. All BVI companies are required to have a registered agent. And if a BVI company doesn't have a registered agent, for example, if the registered agent resigned, then it is liable to be struck off. And there is a notification to the BVI company. So a registered agent is the agent that administers the affairs of the company in terms of attending to filing. Why are they important? They are important because the AML regime that we have in the BVI requires a registered agent to obtain know your client information. So the registered agent must know who the UBO is. And they also have the register of members and the register of directors. So when you apply for a Norwich Pharmacal order against a registered agent, you will be seeking essentially to identify the person behind this company, because you can't do so from a public search. The court, the jurisdiction exists, a BVI court will, let's just say I've never not gotten one. The BVI court.
Great track record.
Well, no, but it's not a difficult, the jurisdiction is there, the exercise of the discretion is not a weighty one. And it is against the registered agent itself, not against the company against whom you intend to sue. There are a number of sort of interesting aspects to Norwich Pharmacal orders, or add-ons, if I might call it that. You can get it ex parte, so without the registered agent being aware of it. And you can get it with a gag order. because typically registered agents will communicate with the UBO or communicate with the client of record, and you don't want to tip that person off that you're looking for information. So we usually ask for these add-ons. So we usually apply for it ex parte. You can get it urgently. You can get it on very quickly before the judge. The commercial division in the BVI is very efficient and very reactive to urgent applications. And as I say, you can get a gag order. But the cost, because the registered agent is a neutral party, you will have to pay their cost of having to source the information. But that does not tend to be significant. It's usually about $2,000 or something like that. So it is a wonderful source of information when you couldn't have had it otherwise by public sources. And as I say, the court will typically provide that or grant the order. The scope of it can be and will be necessarily narrow because there is a limit to what the registered agent is required to keep. But essentially, we can ask them to hand over their files of the BVI company. You'll be able to identify who the UBO is. As I say, it's usually obtained at this before proceedings have been commenced because we don't have pre-action disclosure. It is unlikely that you will obtain it after proceedings have been commenced because you've already identified your UBO to sue that person. But there's nothing in the application of the principle which means you could not obtain it in the course of litigation. But why would you? You could just seek standard disclosure and specific disclosure in any event.
Well,
so
exactly,
we use it quite a lot. We use it quite a lot in the BVI, and it's as I say, it's not difficult to obtain. It doesn't tend to be very expensive. The registered agent rarely puts up a fight, if at all. They always operate as being a neutral party to the dispute. Their costs tend not to be significant, and you obtain the register of members, register of directors, any information that would have been provided to the registered agent in order to incorporate the company. So copies of passports, identification, addresses, that sort of information you could get from a Norwich Pharmaco order.
That sounds really, really very useful. And I think we're all going to take away the point about the registered agent in the BVI as a useful tip.
Yeah.
Thanks very much, Tamika. I'm going to move on to Nick, just to talk quickly about some of the restrictions on the use of information. And I did flag right at the outset the Evenwyck and Schlossberg decision. Nick, can you run us through in a couple of minutes just some of the restrictions on the use of information and ways it might be possible to avoid falling foul of Evenwyck?
Sure. So I think the starting point is that information collected in the insolvency realm under the 234 through 236 and then the 366 equivalent provisions in bankruptcy it is obtained under the threat, express or implicit, of compulsion. So the information recovered is inherently confidential, and it is to be used for the purpose that it's there for, which is to fulfil the functions of office, get in, realise and distribute the estate. So with that oversight, I think the starting point is information you recover, be careful in where you deploy it and think about it before you deploy it. And with that, I think you avoid the major trip-ups. There is a key distinction between personal and corporate insolvencies you touched on following the Evenwyck Schlossberg decision and then the Leeds and Lemos decision, which I think clarified the Court of Appeals take on it. The history and the background to all that, I think, could take the whole seminar itself. So I think I'll limit to saying that the effect of it is that documents recovered from, let's say, solicitors' files or from the bankrupt, which contain privileged, do not vest in the estate, or they're not assets of the estate and don't vest in the trustee. So I think the key part to note there is where you recover information, obviously it's especially relevant from solicitors, but it's also relevant from information passed by other people. A privilege review is very, very important before you disseminate the information anywhere. It's not for the trustee to use the bankrupt's privilege. It has created a bit of I think maybe a bit of a tidal wave of consternation at the outset, and maybe died down to a bit of a ripple of consternation as people have processed it. it always sounds as though, well, how can, if I have privileged information in my hands that says that the bankrupt has divested himself of significant assets, why can't I use that? Because that's for the benefit of creditors. I think the starting point there is but both the case of Leeds and Lemos and the case of Avonwick had issues of iniquity which weren't really explored or developed. But what we always need to remember is that not all solicitor client communication is privileged, or not all information on a solicitor's account file is privileged. So solicitors are a great source of information for a few reasons. One, they tend to keep reasonably tidy files, so they're in good order and contain lots of information. Two, they're often advising in the zone and around the zone of insolvency, so can often go to intention, so what a bankrupt is trying to do with his assets, where it's relevant to, for example, a 423 or a TUV. And thirdly, in my experience, they tend not to put up a great fight because they understand that they, provided they're doing it under the order, that they will be obliged to give the information over. So they're a port of call for bankruptcy and well, all investigation really. Ways to navigate, I think, are reasonably straightforward. Taking apart the iniquity, which would be if there's if the privileged information is actually, or if the information which would otherwise be privileged is actually driven at criminal actions or fraudulent actions, then on application to court, you would be able to say this, there is no privilege attached to that document, I can use it. Putting aside that, which is a very fact-specific, obviously, example, my tips that I always try and follow myself is, when I receive information, I always try and categorize it in my electronic and hard copy files as to where it's come from, because it's very easy when you get it to remember what it is, but 2 years down the line when you're in the middle of proceedings, it's not always obvious to you where it's come from. It's a slightly basic tip, but it stops us tripping over ourselves sometimes. And actually, in a case I was involved in after the first instance Avonwick decision, but before the clarifications, we took the privileged information at that stage and cross-checked it against his servers and his other activity at the time that the privileged information was being given. And in that case, we found that he disseminated his information quite widely to his network of kind of, would say right-hand men, but his kind of front companies and front advisors to say, this is what you have to follow now, because this is going to shield my assets effectively. And in doing so, the privilege was lost because the inherent confidentiality in the client-solicitor relationship had been shared too widely. So it's always worth checking what's going on around that time. And then finally, I think, whilst it's a change in not being able to use the privilege directly, I think it has to be considered a material benefit to know the answer to a question and know the answer to your investigation before you embark on it. If you have the privileged information, it should identify who you need to ask and what you need to ask to get the information in a way that you can deploy in litigation. It may have cost consequences and implications, but I don't think it prevents trustees or from exercising their functions.
I think that's a really good point, Nick, and I'm sure the Blair will agree. You never ask a question you don't know the answer to, so it always helps with that sort of thing. Finally, Colin, I promised I would come back to you to talk about some practical tips and guidance, whether that be with on the chapter 15 or generally in collecting evidence. I'm going to give you just a few minutes. So if you could give us any of your top tips, that would be smashing.
Yeah, conscious of time, so I'll stick to chapter 15 and some practical tips that I've deployed on the numerous times I've deployed that strategy. First one is, when you're applying for chapter 15, you have to demonstrate that the debtor, the bankrupt in this case, has got assets in the jurisdiction, assets in the US. In my example, that was satisfied because he had property, bank accounts, and cars. So that ticked that box. But for me, and the important thing was to establish the appropriate venue to bring the recognition. Not every district in the US is comfortable with the idea and concept of international recognition of insolvency proceedings. Some districts are far better than others. So the Southern District of New York is a good one. Delaware is another good one. And the Middle District of Florida is another good one in terms of district courts that have experience and understand international insolvency. So in my case here, I had an asset in Tennessee and another asset that I was aware of down in southern Florida. Both those district courts are not particularly well known for their international insolvency reach and understanding, to put it diplomatically. So what we did was we placed $2,500 US in my trustee's client account with our solicitors in the Middle District of Florida. And that gave the Middle District of Florida venue and jurisdiction to hear the recognition, because the Middle District of Florida and the judges in that circuit are far more likely to give you the recognition that you want because they understand the process. So just a tip there is to make sure you pick the right venue when you're seeking your Chapter 15, and you can manipulate that jurisdiction district by way of putting funds in client accounts with your solicitor. And just quickly, the second one was, I mentioned earlier that Chapter 15, once you've obtained the recognition, you get an automatic freeze over the assets that are in the jurisdiction. Obviously, you have to wait till recognition, and that can be, depending on court timetabling, anywhere between, a few weeks and a few months. So if you fear that there is a risk of dissipation, then you can make an application to the US court for recognition of interim relief and effectively get an interim freezing order over the assets that you're aware of. And all you really need to do is demonstrate to the court there that you have a substantial likelihood that your foreign proceeding will be recognised under Chapter 15. So the threshold's not overly onerous. But what you might need to do, depending on the type of the asset you're looking to freeze, is put up a bond security. In the case that I was talking to earlier, we went down that route. We got an interim relief order while we waited for the recognition, and that worked out quite well because the debtor had been trying to sell the property. So we were able to, as part of the interim relief, get this early disclosure. So he subpoenaed his solicitors, who confirmed that he was in the process of selling the property. And the ironic story there is that I asked the retailer in Tennessee whether or not the purchaser would be spooked by the fact that, I'm on the scene and there's going to be a court order transferring the property from the debtor to me. And the retailer said, no, I don't think so. The purchaser is a bankruptcy judge.
That's brilliant.
So the bankruptcy judge carried on with the purchase, which is very helpful because we expedited the flow of cash back from the US to the UK to creditors. So quite a funny story.
God bless American bankruptcy judges. That's fantastic.
Exactly.
I like that one a lot.
No worries.
That's brilliant. Well, thank you all for giving such wide-ranging and thorough explanations. I think that's a great start to the session. I'm going to give you all a break. Tamika, I think we may not see you later, depending on when we click on for the questions. So if we don't get to see you again, thank you so much. That was really helpful.
Thank you.
So we'll give you all a break, and you'll all be brought back for the panel session later. And I'll hand over to Will.
Thanks, Mary. Good morning, everyone. Good afternoon and good evening, wherever you are. Okay, I'd like to introduce my first two panelists. I've got Sarah Brehaut and Neil Williams. Sarah Brehaut is a Guernsey advocate at Walkers, and she's a partner in Walkers Guernsey Insolvency and Dispute Resolution Group, specialising in contentious insolvency and regulatory disputes. She's an experienced, and I can say from personal experience, very effective court-going advocate who frequently represents liquidators in respect of contentious and non-contentious matters before Guernsey's Royal Court in relation to compulsory and voluntary winding up. And I'm going to embarrass her now and tell you that she holds the BPP Certificate of Proficiency in Corporate Insolvency, for which she received the highest exam result in the country. So thank you very much, Sarah, and welcome. Neil is a legal director at Rahman Ravelli. He's a genuine expert in business crime, and in particular cases involving cross-border bribery and corruption cases. He acts for senior executives, corporates and major organisations. His caseload can involve everything from currency fraud, mortgage fraud and charity fraud through to carbon credits and other worldwide white-collar crime issues. So welcome to you, Neil. Thanks for joining us. Okay, so I think we'll start with Sarah. Can you briefly outline the structure around Guernsey personal and corporate insolvency, please?
Yeah, sure, happy to do so. So the corporate insolvency position is really quite straightforward. It forms part of our company's law. And I think we'll talk about that again a little bit later, because we're just on the cusp of having some very useful amendments carried through by way of an ordinance which is going through this year to that company's law. Our personal insolvency law is a little less developed, some might say. It's still got its roots in 1929 legislation, and we talk about people being declared en état de désastre, which is basically in a state of disaster. It can apply to companies as well as individuals, but we tend to use it really for the individuals. Typically what happens with a Guernsey personal insolvency is that you start off with a bog standard debt recovery action, debtor can't pay, and we send the sheriff in. The sheriff goes along and establishes whether the chap can pay or lady can pay their debts. And if they can't, it's at that point that we start what's called the days asked process. And the person who's on days asked has to give an idea of what his assets are. And if there are competing claims by the creditors, he ends up before our commissioners, who look at marshalling the debts and sorting it out in similar ways as in the UK, looking at different priorities in that situation. What's important about Guernsey, though, is we don't have a trustee and bankruptcy regime, so there's no appointment of a trustee in the situation. It's all run by the commissioner, who is effectively the jurat. But what days asked does is it gives the individual the opportunity to go for a declaration of insolvency. Interestingly, it's not something in the last sort of 20 years I ever really see anybody do over here. I think probably because it's a bit cumbersome, it's a bit public, and it takes quite a long time. But the real beauty of the declaration of insolvency over here is that it also then does allow you to go for what's called renonciation. And renonciation is to try and have your debts written off. Unfortunately, it's not quite a smooth process as it is in the UK. There are various limits in relation to whether the court's going to be willing to grant you this renunciation or not. And as I say, I don't think I've ever in the 20 years I've been practicing here seen it being done, actually. That's probably because there are sort of special little idiosyncrasies about it. If your dividend's going to be less than 50p in the pound, then the court probably isn't going to give you that renunciation, so you're stuck with your debts anyway. And if you've got debts to the state, then equally they're not going to allow you to have those written off. So you end up carrying on being burdened with the debt. That only, interestingly as well, deals with your personal assets. So in Guernsey, we have two separate regimes. One is days asked, which is your personal, and then the other is saisie, which is dealing with your real property. So that's the process of literally somebody going through and seizing your real property. That can be quite a fluid process. The courts now have ameliorated the old sort of customary law rules around it. The arresting creditor used to be able to take the house and keep absolutely the entirety of any benefit from it. So if you owned a house worth 1.5 million and you owed the bank $500,000, well, unluckily the bank would be able to walk off with the entire 1.5 million. But the courts nowadays do ask the arresting creditors to confirm that they are going to pay back the balance of whatever is due, and people are given a reasonable time to be able to sell their house as well. So yeah, so personal bankruptcy is a slightly unusual situation still in Guernsey, but it works reasonably well. And in fact, the 1929 laws had certain, I think it was probably based on the 1914, I think, English bankruptcy rules, but had some quite useful trips and tips in them. For example, you could cross-examine the individual personal debtor when you got to the insolvency declaration and renunciation stage. So for when it was written in 1929, it was pretty well up there.
Thanks ever so much. That leads me very nicely on to my first question to Neil. So could you quickly set out what the English rules look like for for interviews and cross-examinations, and how you would deal with a client between the tension between the desire of someone who's the subject of a criminal investigation to say not very much to anybody, and the ability of an office holder to compel information.
Yeah, sure, Will. Well, I think it's fair to say that many of the people perhaps who've joined this panel are deal with administration of bankruptcy against individuals and companies. But whereas my background is from a criminal defence, white collar point of view, we often have clients facing dual investigations, be they by the trustees in bankruptcy or the official receiver, and also associated with that there's investigations by other agencies such as the police, HMRC or the SFO, and that will create tension as to the information which is required in both settings and how that is then produced. Now, to that extent, I suppose I'm a poacher amongst gamekeepers, but from our perspective, we have a different view as to how people approach things in both settings. So it's right to say that the Insolvency Act gives the office holders, be they trustee or official receiver, significant tools at their disposal in order to gather information for the purposes of obtaining information relating to an estate or property and whereabouts of it. I think section 291 generally against the bankrupt compels them to comply with the trustees in providing information. And then more generally under section 235 for office holders or former employees, again, there is compulsion that they must provide information to the trustees when required. But that creates tension if there is, if a person is under investigation, because as you say, there is a tendency to try and not say too much in criminal proceedings for fear of the repercussions, obviously. But then on the other hand, the powers under the Insolvency Act are compelling you to provide the information to the person who makes the request. So it goes against the grain when advising the person in the criminal context. So from what we see, there is in the criminal world, you have a right to silence. You do not have to answer the questions. You do not have to say anything. But when you have the investigations by the insolvency, it's a requirement that you must provide that information to them. And the difficulty is the balancing line between what the information you provide is and how it then affects ultimately in the criminal world. Now, there are exceptions to that, and I think we'll go on to that very shortly.
Yeah, but we are indeed going to do that. Thanks very much. And so are there limits on the use of the information which are obtained through a compulsory interview or cross-examination? And is that different from information voluntarily provided to an office holder?
So where a person is compelled to give information under the powers under the Insolvency Act, section 433 states that no evidence can be adduced in relation to the information provided in subsequent criminal proceedings. There are exceptions if perhaps a person introduces or reduces the evidence themselves or raises a question about it in the criminal proceedings. So if a statement is provided to an office holder, then that can't be used in the criminal proceedings, save for exceptional circumstances. There's also the section 13 of the Fraud Act, which states that a person is not excused from answering questions relating to property, which includes the recovery of property in the administration of an estate. But that statement or admission is not admissible against him for an offence under the Fraud Act and related offences. So that extends it beyond the Fraud Act offences themselves, such as fraudulent trading and so on. But it also extends it to offences where there is an underlying fraudulent context. So there is a protection under the Fraud Act as well for self-incrimination, the fact that they do not or not applied in the criminal, they're not able to be used in the criminal context.
Okay, that's really helpful. Sarah, can I come back to you to compare the situation currently in Guernsey?
Yeah, so currently it's quite different at the moment, although literally in a matter of months it sounds like it's going to be really quite similar. So at the moment we don't actually have any statutory provisions expressly providing for delivery up in relation to liquidators. We do, strangely, for administrators in relation to delivery of statement of affairs, but liquidators don't have that. And there's no provisions in relation to cross-examination applying to the court for an investigator to cross-examine the individuals. We have been using workarounds in Guernsey, so there's the ability for liquidators to apply to the court for directions, and we have been able to have the court make an order or a direction that there be an examination, but that has caused some concern, and that's really what Neil was talking about, is because our law didn't have any statutory provisions for the cross-examination, it didn't have the statutory provisions for protection, so that wouldn't be used in the criminal arena. And in Guernsey, we've still got the absolute right to silence over here. So you can't even draw an adverse inference if somebody chooses not to say anything. So there was an obvious tension there. But as I say, things are about to change.
Yeah, well, why don't you tell us about that?
Okay, all right. So Guernsey has got an amendment ordinance coming through this year, which is going to insert, it's going to fill the gaps really in the Guernsey law. Various different areas, not just in relation to the obtaining of evidence. We're now going to have a proof of debt process. There's going to be specific provisions dealing with transactions at an undervalue, extortionate credit transactions, all that kind of good stuff. What we were really talking about here was about provision of documentation and the ability to examine. There are some slight differences with the UK position. Sometimes we go a bit further, sometimes we don't go quite as far, and I thought it might just be useful to touch upon those. So at the moment under our law, the administrator can get a statement of affairs from a limited number of people, but going forward that power is going to be extended to liquidators as well, and they'll be able to get that from any other person, so it's not just going to be limited to directors or controllers or people involved in the formation. So that gives our court really a very wide reach, which I think is further than what happens in the UK at the moment. And that's also going to apply to applications to compel the production of documentation. That any other person examination as well is carried out by an inspector in the Guernsey courts, not a police inspector, just an inspector appointed by the courts. And I think it looks to me that it's a bit of a hybrid as to what is happening in the UK between public and private examinations and what we're going to be having here in Guernsey. So in Guernsey, it is purely going to be a private examination. So for example, creditors wouldn't be able to ask any questions. And in fact, it's going to be limited just to the officers or former officers of the company who'd be able to be examined. It does, however, build in, it sounds like, exactly the same provisions as Neil was talking about in relation to not using that evidence in criminal proceedings, except for perjury, attempting to pervert the course of justice, and of course, if the person interviewed refers to those proceedings themselves. So it provides that check and balance really that we don't have at the moment when we seek to ask the court to carry out those interviews.
Thank you. And so am I right in thinking that that's just in relation to corporate insolvency, not?
Yes, that's right, absolutely.
And is there anything going on in relation to individual bankruptcies which is affecting the position in Guernsey?
Not at the moment. There's been some interesting case law in Guernsey recently, which was a case called Re-Ex, which was a bankrupt case. And that was an English trustee in bankruptcy who'd come across to Guernsey to try and get an order compelling the production of some information and examination before the court. And the initial view of the court was going to be that that would be permissible. The case came up shortly after Singularis had gone up to the Privy Council, so issues of comity were high on everybody's mind. But actually, Judge Lieutenant Bailiff Hazel Marshall was sitting, and her conclusion was that, and this is where the case has to be slightly cautiously, because it was an English bankruptcy, so there was the possibility of using section 426. But what Hazel Marshall said was that because we don't have that specific statutory power to enable the examination of third parties, under the 29 law we can examine the debtor but not third parties, because we didn't have that statutory provision, then she wasn't willing to make that order. Now, I do wonder, and I do think this case is ripe for reconsideration, really, because we were dealing with an English trustee in bankruptcy who could use Section 426 and therefore use the letters of request. She felt that there was no necessity in that case. So I wonder whether if we were faced with an application by a trustee in bankruptcy who wasn't able to use the Section 426 criteria, then actually whether the court would take a different approach for that. But it's interesting. There was some concern about how that would actually impact on corporate insolvencies as well, of course, because what if perhaps we weren't going to permit it because there wasn't a statutory provision there as well? Well, I think the reforms in Guernsey are going to solve that problem now, so it's probably not something we're going to have to worry ourselves about. That said, my experience of IPs over here has generally been that we don't need to get to the courtroom door. They tend to be quite persuasive in getting the information out anyway.
Yeah, well, good luck with taking a case like that on. Thanks very much. Neil, I'm going to come to you now. And can you give us some practical tips from your point of view as somebody who would be perhaps trying to throw a spanner into the works as to how an office holder might successfully achieve what he wants, which is information, when you've got a situation where there's a criminal investigation going on?
Sure. I mean, it's important to note that the person under investigation will always have one eye into the future as to the potential sanctions and consequences of the criminal investigation. So it's balancing those two competing interests when you have the compulsion to give information to the trustees. Now, ordinarily, as I say, in the criminal context, you have the right to silence, but you have to provide the information under the insolvency rules, or you have to cooperate. But the protections afforded by, say, Section 13 of the Fraud Act in relation to further proceedings or prosecutions where a statement's made, those do extend, but you have to be careful to determine what exactly the information is being provided and whether it falls under the provisions or the security offered by the Fraud Act. So when you're dealing with a person or dealing with a trustee and who requires information which touches and concerns the other investigations which you're dealing with, one practical manner in which we try and deal with matters is by engaging with the trustees or the receiver and try and get the information in advance in written form, so that there is time to consider and go through it with the client and to provide such information as to comply with the duties that the Act requires of them, but also with a mind to whether or not the exemptions under the provisions are included in the information that's being provided. Because what you don't want to do is to throw the client to the lions and they give chapter and verse to many things that they may have done which don't fall under the protections, and then they are potentially liable at a later stage. So it's a very careful balancing act that you have to try and undertake in order to protect the interests of the clients, both in terms of incrimination, but also ensuring that they comply with the requirements placed under them by the Act. So it's a very difficult, it's a case-by-case basis, basically, and depending on the information which is provided to you, you have to assess then whether it's covered by the provisions or the exemptions under the Act.
And have you had any success yourself acting for clients in that situation in limiting the amount of information that you provide to a trustee, but doing that in a way which is agreed with them?
Yes, I mean, that's perhaps our first port of call in terms of dealing with trustees, is to try and engage proactively to obtain what they require, or to obtain information about what they require, so that assessment can then be made about what can be provided, as I say, with reference to the acts and the exemptions which can be afforded to the client. So it's not, in many ways, it's by way of cooperation, because what you're ultimately trying to do is protect your client, both from the consequences of non-compliance and also for incrimination for other matters which may or may not be included within the scope of the investigation which is currently being conducted. So by doing that, we have had success. We've been able to limit the information such that the trustees and receivers are satisfied with the accounts that have been given, and then we face the consequences later on in the criminal aspect, but without the information then leaking into the criminal proceedings.
That's helpful. So as with many things, communication is key.
Communication is key in this case, and certainly when you're tap dancing through a minefield such as the criminal competing interest can be, communications certainly does help when trying to balance the interests of the client. That's great. Okay, thank you very much, both of you. I'm going to move on now to my next two panelists, who are David Harby and Blair Lee QC. David is a partner and head of insolvency and trust disputes at PCB Litigation. PCB are a tier 1 firm specialising in fraud and asset tracing. David is a barrister and a mediator, and before joining PCB, he practised at the Independent Bar and worked at firms in the BVI and the Cayman Islands. David is a regular choice for insolvency practitioners, trustees, family offices, and high net worth individuals involved in complex cross-border and offshore disputes. Blair is a commercial litigator specialising in complex multi-jurisdictional fraud and asset tracing claims and disputes with technical insolvency or company law aspects. She has extensive trial experience and experience of obtaining urgent interim relief, including freezing injunctions in aid of foreign proceedings. Blair was also admitted to the Bar of the East European Supreme Court, the British Virgin Islands in 2015, and has been admitted to the Bar of the Cayman Islands for specific cases. So welcome to you both. Thank you very much for joining me in our second panel session. Okay, so I'm just going to give a little bit of context as to for our discussion, and that is that judgment has been entered in the client's favour, and the recovery of the judgment debt from a corporate debtor by the more usual processes of execution or attachment of debts is not practical or hasn't been successful for some reason. Blair, I can see you're on mute, but I'm just about to ask you a question. So if you could unmute yourself and prepare yourself to answer it, thanks. What are the main options available for the judgment creditor?
Thanks, Will. I still have not got used to Zoom or any modern technology whatsoever. Hello to everybody joining us, especially everyone joining from Hong Kong so late on a Friday. I know there's a few of you on, and I hope you're at least enjoying your cocktails. As to your question, Will, the most obvious options where your traditional or conventional enforcement mechanisms aren't available are probably liquidation and receivership by way of equitable execution. Now, these are very, very different beasts. A receiver's role is to use his powers to pay down the judgment debt itself. He'll be appointed over specific assets and given very specific powers in relation to the realization of those assets. When he does realize the assets, he'll pay his fees from the proceeds and he'll pay the net proceeds over to the judgment creditor. And when the judgment debt is paid in full, his job will be done. Liquidation, on the other hand, is a class remedy. So this means that the liquidator's role is not limited to collecting in sufficient assets to pay off the judgment debt. He essentially replaces the management of the company, and his role is to investigate the affairs of the company, collect in all the assets, including, if necessary, by bringing proceedings against misfeasance directors or third parties who may have taken some of the company's assets, and then to distribute anything he gets in accordance with the statutory waterfall in the Insolvency Act. So if he makes recoveries, he's first going to pay his own fees and expenses, obviously. He will then pay down any secured and preferential creditors. And if there is then monies left, he will distribute the balance pari passu or ratably amongst all the unsecured creditors. So in the liquidation scenario, the judgment creditor is only going to get paid if there is substantial and very substantial realizations. I should just add another slight sort of difference. I mean, often in the fraud situation, you want to act very quickly, but to get a liquidator appointed, well, that can't be done overnight. There's usually a sort of a 6 to 8 week gap between filing or petition for compulsory liquidation and the court hearing that petition. So usually in the fraud situation, if you've set your heart on liquidation as the end result, you will probably apply, once you've filed your petition, for the appointment of provisional liquidators who will be there to take possession of the company's assets and hold the ring over the hearing of the petition itself. Now, which route you go down, receivership or the liquidation route, is going to depend essentially on all the circumstances of the case. There's pros and cons to both routes, but which one is appropriate for your particular judgment creditor will depend on the facts. And I think, David, you're going to look at some of the pros and cons of the liquidation route.
Yes, that's right.
Thanks, Blair. Well, I'll go on and ask that question then. So, just David, what are the advantages and disadvantages of using insolvency as an aid to enforcement or asset recovery? And are there any circumstances in which you might not want to do so?
Well, first of all, thanks everybody for coming to this webinar, and thanks, Will, for the introduction, particularly as I know that people are on different time zones. So thanks very much for making the effort to attend. Where to start? Well, I guess it's worth just repeating what Blair has said in outline, which is that liquidation or bankruptcy proceedings, at least in the common law world, are generally collective remedies. By that I mean that the appointed office holder is generally obliged to act in the interests of the body of creditors generally, rather than an individual creditor. Of course, you've got to take into account that there may be issues about priority. Blair obviously mentioned that generally speaking, creditors are paid pari passu, but of course where a creditor is secured, then there will be a different regime in relation to their payment. But within that context, there are a number of advantages. We've already discussed some of these. They are namely that the office holders, at least in England, tend to have greater statutory powers than claimants or creditors. And that obviously includes an ability to obtain disclosure from directors or an individual insolvent, and indeed those caught up in the affairs of the insolvent. It also entails the power to take action to unravel transactions at an undervalue or to attack preferences that have been given to creditors. And these powers are particularly useful where a particular claimant is concerned that a company or the directors of a company has been taking steps to reorganise their affairs to frustrate any judgment or order at the end of the proceedings. The other advantage in England is that office holders in liquidations have the power to bring claims against directors of companies and indeed office holders of companies via a summary procedure under the misfeasance provisions in section 212 of the Insolvency Act. And that, of course, whilst it doesn't give a cause of action in itself, can speed proceedings up and thereby save costs, time and energy. But there are also disadvantages to an insolvency regime. And it's important to consider, amongst other matters, as I've just mentioned, whether there will be any competition for assets and whether it's likely you're going to be paid out at the end. If you're an unsecured creditor ranking behind secured creditors and of course the office holder's own costs, as Blair has mentioned, it may be that there is very little left for you at the end of that process. And of course, the insolvency regime itself may not be suitable for every entity. So, for example, if a company has good cash flow but is relatively asset poor, then the impact of insolvency may actually be that the amount that's available for creditors is reduced. Of course, administrations and other forms of arrangements may not suffer the same consequences. So, for example, administration is often put into place in order to keep a company going as a going concern, has at least that as one of its statutory objectives. And you also need to consider whether the costs of the appointment of the liquidator, I suppose in a similar vein, which without bashing insolvency practitioners, everybody's got to earn a living, may be expensive. And you have to ask yourself whether or not their costs and the costs of the process, including any litigation that may be pursued, whether you need litigation funders to get involved in that, etc., and whether or not there are going to be sufficient realizations, are ultimately worth the benefit to be obtained by putting that company into an insolvent process. Finally, one of the other things that may be worth throwing into the balance and weighing up is whether the defendant is based in one jurisdiction or whether it has assets or subsidiaries in another. And it might be worth weighing up the pros and cons of the different methods of enforcement that are available in each of those jurisdictions. For example, it may be possible to leverage disclosure, or the provisions enabling you to get disclosure in one jurisdiction, to support the liquidators or in office holders' investigations, or indeed litigation in another. Of course, we've just talked about the limits of the use of obtaining disclosure via an office holder, including privilege, for example, and the inability to use disclosure for the purposes of litigation. But nevertheless, there may be differences between the regimes that enable benefits to be gained in others. And it's also worth considering whether, and I'll come on, there's another question that's going to be posed in a few moments, but it's also worth considering whether it's actually easier to pursue an insolvency, or whether it's more effective to do that rather than pursuing some other form of enforcement mechanism. And Nick mentioned, for example, the expanding role of receivership in England, which tends to be supported by Canadian case law. There's a recent case in the BVI called Micros that actually limits, it's a recent judgment of Jack that puts limits on the ability to appoint a receiver, his name is execution receiver, in that jurisdiction. And so it's worth looking at the differences between jurisdictions in weighing up, of course, which process or option you want to pursue.
So another sort of forum shopping, really.
Yes.
Great. Okay, thanks so much. Okay, Blair. So it's become obvious in this whole process that the directors have stripped the judgment debtor of all its assets to avoid enforcement. Happens sometimes. Is there any point in putting the company into liquidation?
Yes, there is. I'm not saying it's the only option, but I think there are three good reasons to still consider liquidation. First, as David has already alluded to, and other speakers this afternoon have alluded to, the liquidator will have very wide statutory powers of investigation. And those are not powers that the creditor, the individual creditor, is going to have. Because of that, it's probably going to be an awful lot easier for the liquidator to investigate the director's fraud and track down the stolen assets so he can bring proprietary claims to recover those assets. The second reason why liquidation might still be preferable is because it may be extremely difficult for the judgment creditor to frame its own cause of action against the directors. Obviously, the directors owe duties to the company from which they have stolen monies, and the company has a cause of action against the directors in relation to that theft. But it's very rarely the case that a creditor can actually create or fashion cause of action against the directors itself. Thirdly, even if the creditor does manage to fashion some sort of cause of action, he is probably going to find that that cause of action, at least on the present state of the law, is barred by a rule known as the rule against reflective loss. And that, in a nutshell, essentially prevents creditors and shareholders from bringing claims against a director for a loss which merely mirrors the loss which has been suffered by the company that's been defrauded. So in our example, the directors have stolen money from the company, therefore the company's asset position has been reduced, and therefore it is not able to pay its creditors, including the judgment creditor. If the judgment creditor sues the directors, he is essentially suing the directors for the loss that the company itself has suffered. There is a relatively recent Court of Appeal decision called Marix, which confirms that the rule against reflective loss bars not only shareholder claims, but also creditor claims. We've been waiting for a very long time now for the Supreme Court to say whether the Court of Appeal got that right. But I think most commentators in this area think that the Supreme Court will probably uphold the Court of Appeal decision, and so it will be continue to be extremely difficult for creditors to bring their own causes of action against misfeasant directors.
So bringing the liquidators is the only option. Yeah.
Well, not necessarily. I think David might have other thoughts about what the creditor can do in that situation, but I'm now usurping your role again.
Okay, so let's assume then that the creditor is keen to keep control of the proceedings against the fraudulent directors. Are there any options available which might get around the rule against reflective loss?
Well, off the top of my head, one option may be to consider bringing an action under section 423 of the Insolvency Act. The title to this section actually is quite misleading because it talks about actions for transactions defrauding creditors, but there's actually no requirement to show fraud or dishonesty, and it's also contained in the Insolvency Act, and it's not actually an insolvency provision at all. Or well, I suppose tangentially it is, but you don't require the insolvent or the defendant rather to be either in an insolvent process or getting close to it. What it enables a creditor, amongst others, to do is to bring proceedings to court. Bring proceedings against a company, for example, in relation to a transaction that has been entered into at an undervalue, and where they can show that it has been undertaken for the purposes of defeating creditors. And it provides the court with very wide remedies indeed, including the ability to make orders against third parties and to vest property back in the company or in another person. And one of the beauties of this section, or the advantages of this section, is that it does get around the problem with reflective loss, and it's possible for a claimant to make an order, seek an order, which would only be possible in any other circumstances as a result of an application being made by the company itself, and the court can make an order for the benefit of all of the victims, so-called, of that transaction. So it's a classic route around that issue concerning reflective loss, and it also avoids some of the problems that you would have in relation to the provisions governing antecedent transactions, particularly in relation to the various time periods that apply to them. So it's worth considering.
Can I just chip in? Just to say that I don't think it's a complete panacea to the rule against reflective loss for this reason, because it's any application under 423 is treated as made on behalf of every victim of the transaction, as David just said. So this will mean that the court will want to fashion a remedy which protects all the victims. So if there are lots of other creditors, the court isn't going to let the judgment creditor simply scoop the prize. The judge is going to want to ensure that there's an appropriate mechanism in place so that there is some sort of pari passu distribution of assets. So in a sense, 423 is really only worthwhile if there are no other competing claims, or if the creditor is just rather concerned to keep control of the process itself, but is content for the net proceeds of the litigation to be paid over to a receiver or someone else to distribute fairly amongst all the victims.
And can I just add to that as well, Blair? You're absolutely right, of course. There's also restrictions on the orders that are available to the court in relation to third parties, which I didn't mention, and which are worth bearing in mind when we're talking about the limits of the application of this provision. So section 4252 provides that an order may only affect the property or impose an obligation on third parties to the transaction, may not do so where that transaction was entered into in good faith, and where the party didn't have notice of the relevant circumstances. So it's important to bear in mind, obviously, the limits of the provision.
Yeah.
Okay. Thanks very much. Okay, Blair, so when might appointing a receiver make more sense than placing the debtor into liquidation?
Well, I suppose one very obvious example would be where the debtor is very clearly solvent, but is taking every step he can think of to impede enforcement against his assets. There is a relatively entertaining case called Cruise City against Unitech. It's a decision of Mr. Justice Mayles, as he then was. And the facts of that case are particularly illustrative of the type of case where receivership will be appropriate. I do commend the judgment because it's, as I say, it is quite entertaining in parts. But just to outline the facts there, City Cruise was trying to enforce a London arbitration award, which had a value of about 350 million, against Unitech, which was an Indian corporation. The Indian corporation, Unitech, had very, very substantial assets, well in excess of $1 billion. But it made it very clear that it was not going to pay the debt, and it was going to take every imaginable step available to it to stop Cruise City enforcing its debt. Cruise City had investigated the Indian corporation's affairs, discovered that it had lots of shareholdings in foreign subsidiaries, but it couldn't really get any feel for what assets those subsidiaries held. It had also tried to was bringing proceedings in India to appoint a receiver in India over the defendant. But the defendant, of course, was resisting those proceedings. And the first instance process or application was going to take 3 to 5 years. And then if there was an appeal, which there inevitably was going to be, that would take another 5 to 8 years. So obviously the judgment creditor was getting very frustrated, and so it came back to London and asked the English court to appoint a receiver by way of equitable execution. And Unitech quite robustly defended that application. One of the things it said was, well, there's no reason why Cruise City shouldn't seek to enforce its arbitral award in the various jurisdictions where Unitech had assets. And superficially, that might seem like a good argument, because you should only be appointing a receiver where conventional methods of enforcement aren't available to you. But Mayles J thought that Unitech had rather a lot of brass neck for running that argument, when they were saying in every other jurisdiction that the applicant, City Cruise, couldn't, in fact, enforce the arbitral award in that jurisdiction. So he got annoyed, but in a very entertaining way. And he said that it was a completely appropriate case to appoint receivers, not least because the asset structure lacked transparency, and a receiver would be able to get in and actually find out what assets the subsidiaries owned. And once they knew what assets they owned, they could decide how best to realize them. Because it mightn't be, for example, the sensible thing to sell the shares, or it might not even be feasible to sell the shares, but there might be valuable assets that could be realized to pay down the judgment debt. Another thing to note about the case is that obviously they were seeking to appoint receivers over foreign assets. And Mayles J was very clear that the court had jurisdiction to do that. But the defendant argued, well, you might have jurisdiction, but none of the foreign courts, and certainly not the Indian court, they're not going to recognize the receivership order. And Mayles said, well, and I'm actually going to quote him because, well, I found it a bit entertaining, but he said, but the sanction of contempt proceedings in London will remain. In circumstances where the directors of the defendants may wish to come to this country in business or for pleasure, the prospect that their next visit may be for a more extended duration and in less comfortable accommodation than anticipated should provide a real incentive to comply with an order. So the fact, and that, you know, is obviously a very important factor to bear in mind, because it can often be more difficult to appoint liquidators over foreign seated companies than it is to appoint a receiver over foreign assets.
Great, thank you. I certainly will be reading that judgment. It sounds very entertaining. Okay, finally, David, do insolvency powers have any particular advantages when dealing with enforcement or asset recovery on a cross-border basis? And are there jurisdictions where it might cause more problems than it solves?
Well, as Blair alluded to, I suppose the answer to this question really depends on an examination of the jurisdictions that you're looking to seek recognition or enforcement in. And by that, I mean those jurisdictions which operate a sort of territorial, in the language of academic insolvency study, as opposed to universal or modified universalism, are like to present more difficulties if recognition is sought, obviously, than those that are, for example, signatories to the UNCITRAL Model Code or have a more liberal attitude to international insolvency and comity. And one example until recently was Singapore, which had quite a strict territorial regime. You had to go and seek appointments separately in Singapore until the recent Companies Amendment Act came into force. And just from my own experience, at least in terms of forum shopping, South Korea can present some interesting issues in terms of getting appointed first. So it's worth looking at whether or not it's possible for you to seek enforcement in that jurisdiction, what the rules say about that, including if you want to appoint a receiver, whether actually appointing a receiver is going to be easier or more difficult, and also considering the advantages and disadvantages of an insolvency, including the rules that pertain to that insolvency and issues of priority, etc., in each jurisdiction. And of course, you have to work on a case by case basis. Just looking forward, it's going to be interesting to see what will happen after Brexit, because at the minute, I think there are only 5 member states that have adopted the UNCITRAL Model Code. That includes the UK under the CBIR. And of course, the UNCITRAL Model Code in itself is not a panacea. Obviously, states are free and have enacted and implemented it in different ways. But I think after Brexit, given that there are so few member states at the moment that have that provision in their domestic legislation, after the 31st of December, insolvency practitioners are going to have to look very closely at the domestic laws of those countries if they have main proceedings in the UK and are looking to obtain recognition, for example, say in Spain, Germany or France, and they're going to have to look at what their domestic laws say about obtaining that recognition. And so actually the distinction and the thought process that goes into whether or not you want to seek enforcement of a judgment, or whether or not you want an insolvency or you want to proceed in some other way, is actually going to happen a lot closer to home than potentially we thought a few years ago. So in answer to your question, it really does depend on an examination of the rules in the particular jurisdiction where those assets, subsidiaries are found, and obviously you need to ensure that you take appropriate local advice.
Great. Well, thank you very much, both of you. That was fascinating and really useful. We've got a couple of questions. I'm going to ask all of the panelists to switch their videos on, so you are all back in the room. And we'll deal with the questions that we've got. If anyone wants to send in any questions while we're talking, we can certainly field them. Mary, do you want to kick off and sort out the question that we've received?
Yeah, no problem. So this one actually comes from one of Will and my colleagues, Daniel Staunton at KN. And I think it's a question to probably to everyone. Under section 246 ZD of the Insolvency Act, there are there are powers of administrators and liquidators to assign causes of action and proceeds to third parties. Have the panelists had any experience of using these powers in practice? If yes, were they effective? If not, is there a reason why they might be ill-used or ineffective? And then the third part of the question is, could this be a way for a party to get around the reflective loss rule? So if we start perhaps with maybe some experience of using these powers.
I have to say I'm not familiar with the provisions off the top of my head in terms of their exact wording. I know Blair's looking at Celia Millman at the moment, but in terms of the assignment of office holder claims, yes, they're often used by insolvency practitioners or considered because it's a way of removing risk, and actually they're of interest to litigation funders at the moment, because often litigation funders, and I don't want to plug any particular names, will either accept the entire assignment of the claim, or will look to fund the insolvency practitioner. And obviously, if they accept the entire assignment for a slightly reduced fee, then it takes the risk away from the insolvency practitioner. They get something now that they can distribute to creditors, and it's off the balance sheet, so to speak. I'm not sure how it would get around the issues regarding reflective loss. In a sense, the claims that have been assigned that vest in the insolvency practitioners are claims that are personal, generally speaking, to the insolvency practitioners or otherwise vested in the company, and so they're not really claims that creditors as individuals or as individual entities would bring anyway. So in that sense, unless Blair wants to correct me, I don't think they're really an answer to the reflective loss point.
Mary, I've assigned quite a few claims. Sorry, Blair.
Go ahead.
Yeah, I've assigned quite a few claims, and I think one of the important factors is Will, David, and Blair were mentioning, in these fraudulent cases, by the time I get appointed as liquidator, there's often nothing left, and you can end up in post your investigation having numerous different claims you could pursue. And obviously commerciality has got to be an important consideration. So I had a case where we had a number of transaction undervalue claims, somewhere between 50,000 and 100,000. You know, I'm sure, as we all know from experience, when you start pursuing those claims and they become protracted, quickly the commerciality goes out the window. It's difficult to justify how you could make a net return, let alone cover your own costs. So I think where you've got an estate with no assets and no funding available effectively, and some bigger claims to pursue, where you've got those smaller claims, and then you can assign them for value to help fund disbursements and to fund the bigger claims for the benefit of the creditors, I think it can be a really useful option.
Shall I just comment on the rule against reflective loss? In fact, that's actually spot on, because one of the policy reasons behind the rule against reflective loss is the concern that one creditor might steal a march on all other creditors. But if the office holder is controlling the process of what actually happens to the asset, which is the shows in action, the claim, then he, if he does assign it, he will be assigning it for its true value. That value will be coming into the estate, which then he can distribute pari passu amongst all the creditors. So even though you have a third party bringing the action, there's no actual injustice to the creditor body. There are lots of other policy reasons behind the rule, and again, they are not impeded if there is an assignment. So it's certainly that sort of the introduction of that provision, which has expanded the ability of an office holder to assign, has also reduced the need for the court to invoke the rule against reflective loss.
Thanks, guys. That's all really interesting. Will, do you want to deal with the next question?
Yeah, well, this is from John Fels from PCB. Hello, John. Thanks for your question. So in the first panel, there was some discussion about the use of sections 236 and 366 to obtain information and documents. Until last year, there had been some conflicting case law as to whether or not those powers had extraterritorial effect. John would be interested to hear the panel's experience of making 236, 366 requests of persons out of the jurisdiction recently, and the extent to which such requests are now having more teeth, such that it is unnecessary to obtain local orders to compel production.
John, I'm currently doing one in France at the moment, and to answer your question as to whether it's containing more teeth or whether we need a local order, sadly it's having no teeth and we are almost certainly going to need a local order. We are not trying to compel their attendance, we're trying to simply request documents, delivery up of documents relating to property and title to a property in France, which was part of the liquidation estate, or should be part of the liquidation estate, we will say. It seems fundamentally hopeless to actually enforce it without invoking the local courts to actually make it happen. Is my experience so far. I'd welcome if anybody else has any practical tips that we could shortcut that process.
Can I just add as well? Thanks, John, for a very difficult question. He's another partner at PCB. I haven't got any experience of, well, I have got experience of it, but the most recent experience that I've got is actually in relation to a Luxembourg case where we have a Luxembourg liquidator looking to use his powers under the European Union insolvency regulation as against a company. In England, for disclosure of information, I should say, somebody was caught up in the affairs of the insolvent in England. And it's same as you, Nick. He has got a Luxembourg order, but I think we're going to have to go to the English court to enforce it. It's just being ignored. So I'm not sure how effective. I'm not sure that's an indictment of the EUIR.
Well, your next step here would be obviously compel them for attendance and even potentially have the court issue a warrant, which simply is irrelevant when you're dealing with other jurisdictions. So I would love someone to tell me that they're having better experiences than I am. I'll take the silence maybe as a no.
I was just about to say that doesn't sound good, does it? I'm just wondering whether we have any other questions from anyone. I do have one which is a little bit, perhaps a little bit unfair because it's about a decision published this morning. So no need to put anyone on the spot. It's the Debenhams provisional liquidation. They tried to apply to put a provisional liquidator in place in order to investigate the pre-pack sale. And that was rejected by the courts. Reactions from the panel, please. Colin, I saw your eyebrows go up, so you've obviously got a view on this.
I mean, that sounds like an interesting application to be made, and maybe the next nail in the coffin of pre-packs would be my, pre-packs again under the spotlight.
Yeah.
Does it raise a separate issue, which is how effective is the pool, and does anybody actually use it?
I think there are people using the pool, but as to its effectiveness, I couldn't possibly comment. But the application certainly sounds novel. But I mean, normally you would expect conflicts administrators to be appointed to investigate the pre-pack. So I don't know why they went down the provisional liquidation route here. We'll read the judgment with interest.
Well, I don't think we have, I haven't seen any hands up. I think we've dealt with Alina's first question and those last two. So I think it just remains for me to say that I'll be staying silent in Guernsey with Sarah. I'll be tap dancing with Neil. I'll be choosing my US district carefully with Colin, and I'll definitely be starting my searches in the basement. And I'd really like to thank everyone on the panel for a really, really interesting session, and for everyone for attending and for their questions.
No, thank you very much all.
Thanks.
It's been a pleasure.
Yes, thank you.
Thank you all.
For your weekend.
Yeah. Bye-bye.
Bye.
Bye.
Enjoy the sunshine.
Bye.
Bye-bye.